Welcome back. Um, we are going back after really good committee discussion this morning on 585. Department of Financial Regulation was listening in and wanted to give us some additional information or maybe help clarify things for us.
Yes,
So,
thank you.
thank you for coming in on such short notice.
Yeah, of course. Kai Sampson, Commissioner of DFR. Do we have Hillary with us? Yes. So Hillary is an attorney in our department. You've met her before. I want her to, if she would just go through any commentary from her observation of the testimony about how a Blue Cross board member is appointed, what the powers therein. I think that helps understand why from our position, we need a little more Vermont flavor, Vermont-wide flavor. So Hillary, can you just share briefly, we have about 10 minutes total, observations, or not observations, your analysis.
You can take your time.
Okay.
Since we bumped 585 from this afternoon.
Sure. I'm Hillary Borcherding, Assistant General Counsel for DFR for the record. A few of the things that I have shared with the commissioner in the time between, one is there was some discussion of the appointment of Blue Cross Blue Shield board members. And I didn't hear all of that testimony, but I wanted to clarify what we understand that process is. First, that there is the nominating committee and there is a number of factors that are considered, and that nominating and governance committee will provide a list of those candidates, and that they are in fact submitted to the sole member of the board, and the sole member of the board being Blue Cross Blue Shield Michigan, who has the sole prerogative to appoint all members to the board of directors. So really the final say of any of the board of directors of Blue Cross Blue Shield Vermont would be Michigan.
And the total breakdown of the current 12 board members?
The current 12 board members are that at least 5 of the directors are individuals who are appointed by the sole member, so Michigan, and then at least 7 of the directors shall be public directors, a subscriber, and the chief executive officer or president of the corporation. So that's where the Vermonters come in.
Yeah, so our proposal would be that 2 of those 7 are appointed by the governor, or I know we've been all over the place on that. I want to.
Can I just ask a clarifying question? Because of the governance structure between Blue Cross Blue Shield Michigan and Vermont, and that Blue Cross Blue Shield Michigan has sole discretion over who's on the board, if we did these 2, they wouldn't be able to say, no, we don't want those 2.
No, because they
Okay.
would, then the bylaws wouldn't be in compliance with the law. So part of the proposal here is that they would have to update their bylaws to be in compliance with the law.
Oh, that's that section that we were like, wonder what that means. Okay. Leslie.
Thank you. Thank you very much. I just need help understanding what that means, the sole nominator. Is that what you're called? Is that what that person's called? And how did that get chosen?
So the sole member is Blue Cross Blue Shield Michigan, and that happened 2 years ago, maybe, when Blue Cross Blue Shield Vermont affiliated with Blue Cross Blue Shield Michigan, and Michigan became the sole member. An affiliation is really a term of art that is used in the nonprofit insurance context that really means that Blue Cross Blue Shield Michigan became the director of the board or the sole members of the board for Blue Cross Blue Shield Vermont. In another context, you might hear it called a merger or an acquisition even, but the term of art in the nonprofit world would be affiliation.
Yeah, I'm just trying to understand the sole member thing idea. I mean, how does it get out of Vermont? How come it went away from Vermont? Because before, I mean, Michigan, of course, rescued Blue Cross Blue Shield. I know it's been paid back, so that's great. How did that happen that the sole member left Vermont?
So about 2 years ago, Blue Cross Blue Shield Vermont submitted a Form A application, which is a regulatory filing seeking to affiliate with Blue Cross Blue Shield Michigan. There was an extensive public process and review. And after that process, there was an order that was issued by the then Commissioner of the Department of Financial Regulation permitting that affiliation to go through with the conditions that are in that order. And that order is publicly available on the DFR website.
Yes,
So
go
this
ahead.
remainder, it's a bylaws issue, right? So the bylaws would have to be updated in order to go forward with this. So then I imagine that the remainder of the board voted for this bylaw change and allowing the sole member to be from the Michigan, Blue Cross Blue Shield Michigan. Is that right? Is that my understanding,
Yeah.
right?
Yeah, it was not a hostile takeover.
Yeah, exactly. So it's like, that's what I'm trying to understand.
And to
It's
be
like-
clear, it has been absolutely a beneficial partnership, affiliation, whatever you want to call it.
Yeah,
But the purpose of me pointing out that aspect, the kind of veto power aspect that Michigan has on the 7 Vermont appointees to the board is that this proposal, for many reasons, or there's many reasons that we put this forward, but one of them is that no matter what happens in that realm, you have 2 appointees that, you know, as explicitly stated in 585, have a separate duty, statewide healthcare policy consistency, and that aren't subject to that Michigan control, if you will, or veto power.
well, let's say,
Go ahead.
we don't want that structure anymore. We don't want to allow Michigan to have that power, sole member. How do we remove that? How does that get removed?
Yeah. This might be
That's
a
a
question.
legal question.
I was
There's
just
a
going to say
lawyer
the
on.
opposite.
Oh, okay.
Oh, great.
I mean, they'd have to, if that represented a change of control, they would have to initiate that and ask through a Form A, which is a form, you know, we have a statute for all domestic insurers that says, you know, acquisition of an insurer or change of control, anything like that needs to be approved by us with extensive filings, et cetera, which is how we got here in the first place several years ago.
So if this is my last, thinking, what you're saying is what you're hoping, I guess, is by having these 2 board members, they would be the only 2 board members not under control of the sole member.
Correct. Well, would you agree with that, Hillary? I mean, not under control, not
Or appointing.
not-
control.
yes.
Yeah,
exactly.
Yeah.
Yeah.
Holden.
yeah.
Sure. I want to get, Hillary, any thoughts on that? Or are we good? Weird not being able to see your colleague.
I agree. I think the one clarification I might make is that pursuant to the language that we've proposed, these board members would be held to every other standard of existing board members' confidentiality. So bylaws, articles of incorporation, any of the standards that the board members are being held to, the appointed officials, the members of the public would be as well. The only difference would be that the sole member wouldn't have to confirm their appointment to the board.
So could we add language to this saying we want the sole member to be from Vermont?
Well,
Well, I mean, you say it's just a Form A, 1A or whatever A.
right. I think, you know, my concern there, again, I think the relationship with the Michigan plan is crucial.
Crucial.
That would muscle them out in a way that would probably cause them to think about ceasing their relationship, which is a beneficial relationship. Does that make sense?
Yes.
Yeah.
But now that we've
But by-
paid out our debt,
Well, it's-
what is what does that relationship give us?
Can I just, I
Yeah.
just want to clear, you're thinking about that debt, that these are not connected in
No.
any way.
Well, I'm not sure, but okay, that's okay.
Yeah, I mean, that's kind of where I was going, that the benefits to Blue Cross go far beyond the access to capital they had. That wasn't even really, I think, contemplated when the acquisition or merger affiliation happened.
Mhm.
It was a nice bonus, I think, when surplus started to decline. That, you know, I think one of the big areas that I'm aware of has been IT support,
Mhm.
you know, things that operationally require scale. It's very helpful for us.
So that's where the original part came from, IT support. Were there other places that?
Probably best to hear from Blue
Maybe.
Cross on the, I wasn't there for the acquisition or for the affiliation pleadings, the Form A. But I know IT is something that they've reported has been an immediate uplift.
Thank you.
in Savings.
I know the
And one-
commissioner, I was just gonna say that hold on one second. I know that the commissioner has more that he wants to say, but I know that Brian has a question. Do you want to wait until after the commissioner finishes what he's saying, or do you want to ask?
I'll
it
wait.
now? And Hillary, did you want to add something?
I was just going to suggest that I would be happy to share the affiliation, the order approving the affiliation that is publicly available, because it does identify some of the areas that the affiliation was attempting to address, the reasons it was approved. And I think it's a pretty inclusive document that might be helpful to review and can answer some of the questions that have been being asked.
So next, I want to cover two things here that came up this morning in your discussion. One is why? Why do we need to do this, or why does the department and the administration feel it's appropriate at this point in time? And then the second one is the slippery slope argument that somehow this is a threat to other nonprofits. Starting with that one, this can only happen by function of law. So the slippery slope argument would be a concern that you as a body would now start passing laws to go in that direction. You know, and being someone that served on different government and nonprofit boards, well, there's no intention of a slippery slope. It's not in this proposal. There is only one nonprofit. The section of statute you're in, nonprofit medical service, hospital service provider. So I really don't think there's a slippery slope here at all. Is there precedent? Well, let's talk about the why. Why did I propose this? Why did we as a department see this as one of many ways to prevent what happened in terms of the claim surge? I don't know how closely you followed that. You know, again, I came back on board here at the state in April. For me, I want you to know the defining moment was when the former president Don George, came to the state asking for, as part of a recovery plan, a $15 to $30 million taxpayer backstop to help them in their recovery. That, and you know, I'm checking with the attorneys about whether I can make that letter public, if that's helpful to you. This is a single state entity. We've talked about how crucial it is to the state. And in my initial testimony on this, I do not want to get into, you know, second guessing, throwing mud, whatever you want to call it, at the performance and management actions of this company. That did happen to some extent in Green Mountain Care Board hearings. And so there's a lot of public data out there and a lot of public scrutiny onto questioning the effectiveness of management and management decisions. A good summary of that, I've asked Joe to send to the committee assistant to post, is in an op-ed by Emerson Lynn in the St. Albans Messenger from last August. I haven't fact-checked every number in there, but that op-ed does a pretty effective job of reviewing the compensation that happened during a time when we're also being asked to provide a taxpayer backstop. And that compensation, which is why you see the other piece of our proposal, approached $1 million for the CEO for a company that was officially asking the state to consider providing a $15 to $30 million backstop. When we talk about a slippery slope of a nonprofit, please raise your hand if you're involved in a nonprofit with that type of salary structure. Now, I said to you earlier in my initial testimony, I don't want to be in the business of determining what the right compensation is, but the general public has weighed in on that. I think the Care Board, in a certain extent, has weighed in somewhat, shared some opinions on that. what I want to be in the business of is making sure the companies that I regulate are governed in a way that those decisions take into account the entire state of Vermont, reputational issues with things like that. I really want to nudge that board of directors to have some fresh thinking, some statewide public policy, not vetoable by the parent or by the affiliated controlling member. That, and I guess I'll stop there and say, like, that is the impetus for this. And again, I'll point out that 2 of 12 board members, this is not an attempt to take over the board. This is an attempt to nudge, influence, provide some fresh thinking for a company that arguably has some management challenges and decision challenges that contributed, many contributors, okay, to the financial distress this company got into. So I'll pause there.
Brian.
So I wanted to go back to the Form A reference earlier, where you, if I understood correctly, you were saying that there's a process that an organization of this kind follows when changing its ownership. What's that? Yeah, I would say ownership or control structure, structure of control. And Blue Cross Blue Shield went through that process and was approved legally.
Yes.
Yeah, so the state allowed this current board structure to come into existence. So I wanted to confirm that I was hearing that. So the organization has done nothing wrong in terms of how they're managing their board, following the rules, following bylaws. But I am hearing is there was concerns about how the finances of the organization were managed. I want to acknowledge that there were other players in the healthcare system who were part of that problem. And so I feel like I'm still struggling with how adding 2 board members would have resolved any of that other stuff. And I'm curious, are there other pathways besides adding 2 board members, like mandating in law that the government comes into a nonprofit and forces like an elected official to now have power over the board, or power over the board membership, even if it's small? Are there other pathways? Like, are there other ways to negotiate with, or to talk with the company around our concerns as a community and let them on their own have the time and choice and way to change their board membership over? Because if they were open to that, then why would we just force this? Like, perhaps this discussion itself and the watchful eye of the public is enough to change the behavior of a company.
And that's fair. It may be. A lot has changed in the last 9 months. But I'll tell you, are there other pathways? Yes, they're currently being used. I have an appointee, or not an appointee, I have a liaison through DFR order sitting in the negotiations now. The care board has a liaison team with the UVM Health with Medical Center. That level, so the other pathway, and I'd like to back away from that. I'd like to let the company, because that's not sustainable. In terms of regulatory action for both hospitals that the Green Mountain Care Board is under, and what we're doing in DFR, we're at a sprint right now. And I'd like the ship to sail itself a little better. And I think governance is how you do that. The order that my department did in August around contracting and finding savings and contracting with hospitals, the appointment of liaison, the Green Mountain Care Board's actions, that's, to me, evidence of why we need to, at a more hands-off level, influence the governance and the decisions that this company makes. So that, because right now, it's getting a little bit too close to we're part of management from a regulatory point of view, as is the legislature. Act 55, the actions of the legislature, the Care Board, and DFR are really unprecedented to unwind whatever mess and whoever's fault it was. There's a lot of players, including us all, regulators, legislators, the involved, across the board, there's responsibility. This is, I will feel more comfortable that as we slowly step away to have two members, and again, in that statute, you'll see that it references their responsibility, those two appointed board members to think in terms of consistent with 94 or whatever of Title 18, I think, the principles of healthcare transformation. So it's a different responsibility and a different lens that 2 of 12 board members will bring to the table. I think it's overblown to be threatened by that, but I know that many people are. From the organization point of view, or from a completely unrelated nonprofit.
I'm Karen, but did I see a hand down here first? Okay, I just wasn't sure.
Simple math question. We were early thinking of the 2 people, assuming we would then have a board of 14 people, not 12. So what's your understanding of how the board ends up being?
Hillary can talk about the detailed sequence of how this would roll out. The reason it says 1/6 is there is the potential that rather than 2 board members rolling off from the current Vermont 7 and being replaced by governor appointees, that in the near term, they add 2. And if they add 2, then, but I believe, Hillary, first they have to submit. Maybe you can take this question.
Well,
Because it's as much legal as it is math, but.
Good, because I was thinking, how am I going to possibly put this in Village Council? I don't.
So we had earlier discussed before you were here, taking out the 1/6 and just saying on 2, and that made 14. That was our simple math from earlier today, but maybe that's not a correct assumption.
I think the reason the 1/6 was involved is because pursuant to the Blue Cross Blue Shield bylaws, they can change the size of the board at any time. So we could add 2 board members and they could change the size of the board to 40. So we wanted to maintain some ratio of influence. And then the 1/6 has the added benefit of being able to provide some flexibility. If Blue Cross Blue Shield doesn't want to roll off board members right now, but instead wait for their terms to expire, then you could have 3 government appointees for a small period of time, and then those would flux as folks' terms ended.
And then once people are on the board, and however they get approved or appointed, they then have a vote as it's like a vote of that. They're not like, the veto power isn't over any of their subsequent actions once they're.
Correct, right.
Yeah.
But they will be like every other board member, and as Hillary mentioned, also subject to confidentiality, code of conduct. They will have no greater or lesser rights than any other board member, except for committee chairs, et cetera.
But the statute does refer to not being as liable or having.
Well, because we've given them duties that serve statewide health transformation, that serve the general public explicitly, it seemed appropriate that they should not be getting sued because they advance an idea or make a vote that they feel is in support of statewide healthcare transformation, but a Blue Cross Blue Shield policyholder, who they may be as well, says that was a breach of fiduciary duty because even though that was better for the state, it was detrimental to the finances of Blue Cross, as an example.
Yeah.
Anything you want to add there, Hillary?
Is that what
I
you-
guess simply just the intention behind those limitations was to put these board members on the same footing as existing board members. They have additional fiduciary obligations, which would mean they have additional liability. And this was intending to equalize that. And you'll notice that the limitations on liability that are included, they actually are taken from the B Corp statutes. So they're intending to do the same thing as we do for folks who are the board members of B corporations.
Okay. Any other questions?
Final thought, I would ask that, again, because I think that opinion piece that I asked Joe to have posted.
It's posted.
Okay, yeah, if before you make a final determination, I would ask that you read that, just because it's a good summary of kind of a lot of chain of events that certainly led my department to take seriously the addition of some greater influence by kind of the general public and public policy and the governor on the governance of that company. Thank you.
Karen, did you have one more?
Just one more. I ended up just glancing at the affiliation agreement and it talks about a $10 million savings within a 3-year period. Has that been realized or shall it be realized?
We get we get periodic reports on that, and I can't remember what the most recent kind of update on that was. There are periodic meetings with my financial staff with Blue Cross. So far, you know, my qualitative takeaway is it's going well. We don't have any concerns about the benefits of affiliation in terms of the expected savings and scale, et cetera.
It's very specific. So I was just wondering
Right.
if it was being monitored.
It is being monitored. I'll see what I can dig up that I can share in terms of the benefits of that.
There'd be a benefit of having the affiliation agreement on our.
We could, I'm assuming
Well,
obviously it's a public document, so.
You found it. and
Yeah.
I hope so.
I know. If Tasha wants to, if somebody forwards it to Tasha, she can post it as comment. So I think I'm going to, well, thank you very much.
I throw in one more comment I forgot.
Absolutely.
I know, it's my trick. I always compare it to Gandalf bringing in the hobbits one by one, I mean, dwarves one by one.
Too hot in the room. I know they don't like being in our room very long.
I did see this proposal, the board addition to the board, and remember you asked that they be part of the compensation committee. Okay, so it is related to just what I would say is better thought and care to overall compensation and accountability, not just to the entity itself, but statewide thought. So I see that's why part of why I'm here today is I feel passionate about that this is an appropriate move given Blue Cross, but also on the comp, they work together, really do. Thank you.
Thank you. I'm going to redraw this later on after we do 583, which after a break, people can take some time if they'd like to read the op-ed. And then I'm going to redraw.
I would like time to read it later.
Okay, thank you. Thanks for coming in. All right. So we're moving to 583. Do I? Right later on, and then, yeah, and then I'll do it after that. Okay. Jen, wanna come on up? So we haven't seen 583 in a while. I will just say that there's, in full disclosure, there's been many meetings with all interested parties and stakeholders and lots of conversation. And what is being presented to us today is sort of a culmination of all those meetings. Truman.
Good afternoon, Jen Carby from the Office of Legislative Counsel. I will put the language up. Unlike when I usually bring you a new draft, this one is not in markup. There's just too many changes. I would encourage you to just think of it as kind of a new bill. It happens to have the same number as a previous.
Didn't even exist.
Can't remember that. This is 2.6. I'll give you all a minute to get there.
30 seconds, like 8 or something.
All right, so this would add a new chapter in Title 33 on clinical decision-making. I'm sorry, in Title 18, Chapter 233. And this is where it's going in statute is in a part. So titles are broken, most titles are broken into very large parts. We usually look at chapters, but But even bigger than the chapters are parts, and there's a part on something around decision-making. That is where the advanced directive statutes go, so I thought clinical decision-making could go there too. This starts with definitions. A lot of these definitions have been in some form in prior iterations, but we start out with just some cross references. So healthcare facility is, we're using the definition from the certificate of need statutes. So the broad definition of healthcare facility. Healthcare provider is in the beginning of chapter 221. It's the window.
It's the window open. Now that people are
Nobody's
looking back.
slamming up yet.
Yes.
A little scary behind me.
I think you concur to the first word of the bill.
So we use the definition from 18 VSA 9402 of healthcare provider, which is a broad definition, but it excludes facilities and institutions. So healthcare provider is people who are licensed or certified or otherwise authorized to provide healthcare services. We have a definition of healthcare services. This one borrows from, I think, the patient financial assistance statutes, and it includes a whole list of services. And we'll see how these kind of come into play later. Healthcare staffing company is a person engaged in the business of providing or procuring healthcare personnel for temporary employment or contracting by a healthcare facility, but not somebody who is temping, offering out their own services on a temporary basis as an employee or a contractor. New definition, hedge fund is a pool of funds managed by investors for the purpose of earning a return on those funds, regardless of the strategies used to manage the funds. Hedge funds include a pool of funds managed or controlled by private limited partnerships. But a hedge fund does not include individuals or entities that contribute or promise to contribute funds to a hedge fund, but do not participate in the management of the hedge fund or the fund's assets, or in any change of control of the hedge fund or the fund's assets, or entities that solely provide or manage debt financing secured in whole or in part by the assets of a healthcare facility, including banks, credit unions, commercial real estate lenders, bond underwriters, and trustees. So, hedge fund. Licensee, and this term is only used once in this new iteration. Other conversations with one of the stakeholders earlier, it may need to come out. I don't know if it ends up being overly narrow, but I'll flag it when it comes up. But it is somebody who's licensed as a physician, advanced practice registered nurse, or physician assistant, who's authorized to diagnose and treat in the applicable clinical setting. We have management services organization, which is an organization or entity that contracts with a healthcare provider or provider organization to perform management or administrative services relating to supporting or facilitating the provision of healthcare services. We have ownership or investment interest is any of the following: direct or indirect possession of equity in the capital, stock, or profits totaling more than 5% of an entity. Interest held by an investor or group of investors who engage in the raising or returning of capital and who invest, develop, or dispose of specified assets. Or interest held by a pool of funds by investors, including a pool of funds managed or controlled by private limited partnerships, if those investors or the management of the pool or private limited partnership employs investment strategies of any kind to earn a return on that pool of funds. Almost done with the definitions, a few more. Private equity group is an investor or group of investors who primarily engage in the raising or returning of capital and who invest, develop, dispose of, or purchase any equity interest in assets, either as a parent company or through another entity the investor or investors completely or partially own or control. Private equity group does not include individuals or entities that contribute or promise to contribute funds to the private equity group, but do not otherwise participate in the management of the group or its assets, or in any change of control of the private equity group or its assets. So that does not include group, is similar for the hedge fund and the private equity group. Provider organization is any kind of corporation, partnership, business trust, association, or organized group of persons that's in the business of healthcare delivery or management, whether or not incorporated, that represents one or more healthcare providers and contracting with health insurers for payment for healthcare services. That includes physician organizations, physician hospital organizations, independent practice associations, provider networks, accountable care organizations, management services organizations, and any other organization that contracts with health insurers for payment for healthcare services. And finally, significant equity investor is any private equity group with a direct or indirect ownership or investment interest in a healthcare facility or management services organization. An investor, group of investors, or other entity with a direct or indirect possession of equity in the capital stock or profits totaling more than 10% of a healthcare provider or provider organization, or any private equity group of investors, or other entity with a direct or indirect controlling interest in a healthcare facility or management services organization, or that operates the business or substantially all the real, or should say personal property or both of a healthcare facility or management service organization under a lease, management, or operating agreement. All right, that was just the definitions.
Mark here.
Yeah, I'm gonna mark my word I added in. I've had property highlighted in green because I thought it was unclear. So last night I made it real or personal, but apparently I haven't made it real or personal. All right, now we get into a news section. And just to kind of put this into some terminology we've used in the past, this is the corporate practice of medicine, the prohibition on corporate practice of medicine section. So it's entitled Limitations on Control over Clinical Decision-Making by Private Equity Group or Hedge Fund. It specifies that the purpose of the section is to ensure that clinical decision-making and treatment decisions are exclusively in the hands of healthcare providers. Didn't have this edited, but again, we're all working hard. And to safeguard against non-licensed individuals or entities such as private equity groups and hedge funds exerting influence or control over healthcare delivery. It says a private equity group or hedge fund involved in any manner with a healthcare facility doing business in this state, including as an investor in a facility or an investor or owner of the assets of a healthcare facility, shall not do any of the following with respect to the healthcare facility. Shall not interfere with the judgment of healthcare providers in making healthcare decisions, including any of the following: determining which diagnostic tests are appropriate for a particular condition, determining the need for referrals to or consultation with another healthcare provider, determining the patient's care plan, including the treatment options available to a patient, and determining how many patients a healthcare provider shall see in any given period of time, or how many hours a healthcare provider shall work, or exercise control over or be delegated the power to do any of the following: setting clinical standards or policies, including clinical staffing levels, controlling or otherwise determining the content of patient medical records, hiring or firing healthcare providers, clinical staff, or medical assistants, or any combination based in full or in part on clinical competency or proficiency, setting the parameters under which a healthcare provider or healthcare facility shall enter into contractual relationships with third-party payers, setting the prices, rates, or amounts the facility charges for a licensee's services. So this is where we may want to revisit whether this should be that limited licensee definition or expanded more broadly to healthcare providers. Setting the clinical competency or proficiency parameters under which a healthcare provider shall enter into contractual relationships with other healthcare providers for the delivery of healthcare services, making decisions regarding the coding and billing of diagnoses and procedures for patient care services, and selecting or approving the selection of medical equipment and medical supplies for the healthcare facility. So all of those are on the list of what we started out by saying: a private equity group or hedge fund involved in any manner with a healthcare facility shall not do any of these things with respect to the healthcare facility. That's what that list is about. Subsection C also says that a private equity group or hedge fund or entity controlled directly in whole or in part by a private equity group or hedge fund shall not enter into an agreement or arrangement with a healthcare facility doing business in the state if the agreement or arrangement would enable the person to interfere with the ability of healthcare providers to make healthcare decisions as set forth in subdivision B1, or to exercise control over or be delegated the power set forth in subdivision B2. So basically to do those things we just looked at in that long list. the organizational form of a healthcare facility as a sole proprietorship, partnership, founding, I think we meant foundation, or corporate entity of any kind shall not affect the application of this section. And nothing in this section shall be construed to prohibit an unlicensed individual or entity from providing non-clinical management, administrative, or business services to, assisting, or consulting with a healthcare facility doing business in the state with respect to the decisions and activities described in subdivision B2, provided that a licensed healthcare provider retains the ultimate responsibility for or approval of those decisions and activities, and the services provided do not constitute an exercise of de facto control over the administrative, business, or clinical operations of the facility in a manner that affects a provider's clinical decision-making or the nature or quality of the healthcare services that the facility delivers. Subsection E allows a healthcare provider who is aggrieved by the actions of a private equity group or hedge fund or any entity controlled directly in whole or in part by that private equity group or hedge fund. So aggrieved by actions in violation of this section may bring an action in Superior Court for appropriate equitable relief. I have a question here about damages, and if so, limit to actual damages, reasonable costs, and attorney's fees. Section 9773 is reporting on ownership and control of healthcare entities. Should probably say facilities and service organizations. So this requires on or before July 1st, 2026. Each healthcare facility and each management services organization must provide to the Green Mountain Care Board either for a healthcare facility or management services organization in which one or more private equity groups or hedge funds held an ownership or investment interest as of a date certain. So I put here June 1st, 2026. The information required by subsection B, we'll look at in a moment, or for a healthcare facility or management services organization in which no private equity or hedge fund held an ownership or investment interest as of that date, an attestation that the facility or management services organization currently has no private equity or hedge fund ownership or investment. So by a date certain, July 1st of this year, each facility and management services organization has to either say, yes, we do have private equity or hedge fund involvement, and here's what that looks like, and we'll look at that next. Or no, we do not have any, no private equity or hedge fund, an equity group, or hedge fund held any ownership or investment interest. So for each healthcare facility or management services organization in which one or more private equity groups or hedge funds holds an ownership or investment interest as of June 1st, 2026, they must report the following information to the Green Mountain Care Board in a form and manner required by the board. The name, business address, and business identification numbers for each person that with respect to the relevant healthcare facility or I'm going to say MSO, Management Services Organization, has an ownership or investment interest, has a controlling interest for healthcare facilities only, is a management services organization, because you don't need an MSO to tell you that it's an MSO, or is a significant equity investor. A current organizational chart showing the business structure of the facility or MSO, including any entity listed in affiliates, including entities that control or are under common control as the healthcare facility or MSO, and subsidiaries. And they must report or provide the facilities or MSO's most recent fiscal year's profit and loss statement and balance sheet. After July 1st, 2026, a healthcare facility or MSO shall report the information described in subsection B anytime that either a private equity group or hedge fund takes on an ownership or investment interest in the facility or MSO that has not previously been reported to the Green Mountain Care Board, or there's a modification to a private equity group's or hedge fund's existing ownership or investment interest in the facility or MSO. So anytime there's new affiliation or change in ownership or investment interest. Then there is an exemption on the following entities do not have to report, and I wasn't sure if entities is the right word here, so that's why it's highlighted in blue. nursing homes, healthcare staffing companies, federally qualified health centers, and entities whose healthcare services delivered in Vermont are provided exclusively through telehealth, including services delivered using telemedicine and store and forward means as defined in the insurance statutes and all forms of remote patient monitoring. Information provided pursuant to this section shall be public information and not considered confidential, proprietary, or trade secret, except a couple instances. Any individual healthcare provider's taxpayer ID that is also their social security number, and any non-business telephone number, email address, physical address, or mailing address of any individual healthcare provider shall be exempt from public inspection and copying under the Public Records Act and shall be kept confidential. And except that all profit and loss statements and balance sheets submitted pursuant to subdivision B3 shall be exempt from public inspection and copying under the Public Records Act, kept confidential, except that the board shall provide copies of these materials or the information contained in them to the Office of the Healthcare Advocate, which shall not further disclose this confidential information. Subsection F, a healthcare facility or MSO that knowingly fails to report the information required by this section is liable to the state for a civil penalty of, and these are taken from some language in a completely different statute, so it's a place to start, but a civil penalty of $50 for each day, not to exceed a total of $10,000 for each year, that it fails to report the required information. And a healthcare facility or MSO that knowingly misrepresents information in a report required under this section is liable to the state for a civil penalty of, again, I just put in a number here, $25,000 for each instance of knowingly misrepresented information included in the report. And this would allow the Attorney General to maintain an action in Superior Court to collect the penalties imposed in the subsection and seek appropriate injunctive relief. Off of page 13, we have sharing of ownership information to improve transparency. This would require on or before February 1st, 2027, and every 2 years thereafter that the Green Mountain Care Board post on its website a report regarding the information provided to the board pursuant to that previous section during the previous 2-year period, including the number of healthcare facilities and MSOs reporting for the year, disaggregated by the business structure of each specified entity. The names, addresses, and business structure of any entities with an ownership or controlling interest in each healthcare facility or MSO, any change in ownership or control for each healthcare facility or MSO, any change in the tax ID number of a healthcare facility or MSO, and as applicable, the name, address, tax ID number, and business structure of other affiliates under common control, subsidiaries, and MSO entities or management services entities as the healthcare facility or management or MSO, including the business type and the tax identification number of each. Information provided under this section is public and shall not be considered confidential, proprietary, or trade secret, provided again that any individual healthcare provider's taxpayer ID number that is also their social security number be exempt from public inspection and copying under the Public Records Act and kept confidential. And this allows the Green Mountain Care Board to share information reported under this chapter with the Attorney General. So this whole chapter, the Attorney General, the Secretary of State, other state agencies, and other state officials to reduce or avoid duplication in reporting requirements or facilitate oversight or enforcement pursuant to Vermont law, or both. And any tax identification numbers that are individual social security numbers and other confidential information may be shared with the Attorney General, other state agencies, and other state officials who agree to maintain the confidentiality of the information. And the board may, in consultation with relevant state agencies, merge similar reporting requirements where appropriate. I don't know if that is still relevant or not. Finally, the act will take effect on July 1st, and I have proposed changing the name of the title of the bill to be an act relating to clinical decision-making rather than an act relating to healthcare financial transactions. Taking out the financial transactions piece. And that is the end.
Can I ask you that last paragraph?
Which last there?
The Green Mountain Care Board may share information. Does that last that last sentence, 14, 15, 16, would that allow the Green Mountain Care Board to ask, say, for instance, the Secretary of State for business information so that they could possibly inform healthcare entities and providers that this is something that needs to be filed?
I don't think this provision is specific to that. I mean, I think
Cover that?
information in the, I don't think so, because this is really about allowing the board to merge these reporting requirements in this chapter with other existing reporting requirements. But I do think, I mean, the Secretary of State's office has information on corporations. It is searchable. It may be able to be provided and, you know, sorted and provided in some form, but I don't think, I mean, I don't think this section addresses that.
Is there existing statute that allows state agencies to work together to get information? Or does it have to be specific to what information that they're getting is the reason they're getting it?
I guess I would say it depends.
Okay.
Yes, in some cases, or some of it that isn't specifically said, but happens as a matter of course in running state government. But I think if we were aware of a particular obstacle, we could look at addressing that.
Thank you, Jen. Thanks for all your hard work on this. Go ahead. Leslie.
Thank you. We got testimony from Dr. Song and Dr. Singh, I think, about the straw doctor who is not living in Vermont. And could you just point me to the language that is there language in here that
No, I don't know that the bill specifically addresses
issue?
that. There's no.
Yeah, there's no language in here addressing that.
So I think we're going to take a very short break. And line up, we have a lot of people in the room. And I feel like, and nobody's on our schedule, like, right? So I feel like I need to get with these people for a few minutes to say, would you love to testify? And I think that's a great question. Okay. Spoiler alert.
Oh, can I ask this
Do you have
question?
any question on the language?
No, but this is, if you're gonna go with that thing, the exemption about nursing homes is a flag for me. I don't know about anybody else. And partly because I come from Springfield catchment area, we know Genesis owns Springfield Health and Rehab at the time. They went bankrupt. A lot of people had harm. So I'm worried about that. So that's an issue for me too. If you're gonna